Hello, my name is Chi Den, and I am with Avignon Realty Coaching and Training. Today, I will go over the promulgated by the Texas Real Estate Commission TREC new home contract, and this is for completed construction. Notice right here, it's not for use for condominium transactions or closings prior to completion of construction. And I will go over this contract paragraph by paragraph. First paragraph is parties. The parties to this contract are the seller and buyer, and then seller agrees to sell and convey to buyer, and buyer agrees to buy from seller the property defined below. Paragraph number 2, property. You need to fill out the lot, the block, and addition, city of, county of, so that all this information needs to be completed. Paragraph 2, property, there's also reservations. Any reservation for oil, gas, or other minerals, water, timber, or other interests is made in accordance with an attached addendum. If this applied, then the reservation addendum will need to be attached to this contract. Paragraph 3, sales price. We have here A, B, C. A is the cash portion of sales price payable by buyer at closing. So that cash portion would need to go here. And then B, sum of all financing described in the attached. So if this contract is actually have third-party financing, then the third-party financing addendum will need to be attached to this contract, a loan assumption addendum, or seller financing addendum. C is the sales price, which is the sum of A and B. Paragraph 4, leases. Except as disclosed in this contract, seller is not aware of any leases affecting the property. After the effective date, seller may not, without buyer's written consent, create a new lease, amend any existing lease, or convey any interest in the property, and check all applicable boxes. A, that's residential leases. B, fixture leases. And then C, natural resource leases. Paragraph 5, earnest money and termination option. So that's A, delivery of earnest money and option fee. That's within 3 days after the effective date. Buyer must deliver to escrow agent at this address the amount of money as earnest money, and then there's this amount money as option money, option fee. The earnest money and option fee shall be made payable to escrow agent and may be paid separately or combined in a single payment. And there's 1, 2, 3, 4 more to earnest money and termination option. And then B is termination option. C is failure to timely deliver earnest money. This is what happened. And then D, failure to timely deliver option fee. And this would be what happened. And bold text, time is of the essence with this paragraph, and strict compliance with the time for performance is required. And then paragraph 6, title policy and survey. Title policy A, seller shall furnish to buyer either at seller's or buyer expense an owner policy of title insurance, and then issue by the title company. Name would go here. Under A, there's 1, 2, 3, 4, 5, 6, 7, 8, and 9. And then there's B, commitment. Within 20 days after the title company receives a copy of this contract, seller shall furnish to buyer a commitment for title insurance and at buyer's expense, legible copies of restrictive covenants and documents evidencing exceptions in the commitment other than the standard printed exceptions. And then there's survey. Survey must be made by a registered professional land surveyor, acceptable to the title company and buyer's lenders, and check one checkbox only, either 1, 2, 3 here, either the seller furnished to the buyer an existing survey, or within X amount of days, either the seller will pay for the survey or the buyer will pay for the survey. And there's time for objections. D, E, this is title notices. Under title notices, you have abstract or title policy, membership, and property owners association. So if the property either is or is not subject to mandatory membership in a property owners association. And black bold text, you are obligated to pay assessment to the property owners association, and the amount of the assessment is subject to change. Your failure to pay the assessment could result in enforcement of the association's lien on and the foreclosure of the property. Another bold black text here is, if buyer is concerned about these matters, the track promulgated addendum for property subject to mandatory membership in a property owner association should be used. And then we have statutory tax districts, tidewaters, annexation. Then 6, property located in a certificated service area of a utility service provider. 7 is public improvement districts. 8, if there's any transfer fees, needs to be disclosed. If the property is using propane gas system service or in a propane gas system service area, then that needs to be disclosed. And also notice of water level fluctuations. That's paragraph 6. Now we're going on to paragraph 7, property condition. Under property conditions, we have access, inspections, and utilities. And B, acceptance of property condition as is, either checked 1 or 2. Then there's warranties, and then D, insulation. We have check only 1 here under insulation. Then E, lender require repairs and treatments. F, completions of repairs, treatments, and improvements. And then G, environmental matters. H, seller's disclosures. Except as otherwise disclosed in this contract, seller has no knowledge of the following here, 1 through 6. Then I, residential service contract. Okay, a buyer may purchase a residential service contract from a residential service company licensed by tract. And bold black text, the purchase of a residential service contract is optional. Similar coverage may be purchased from various companies authorized to do business in Texas. Paragraph 8, brokers and sales agents. So broker and sales agent disclosure. And this is, why agent, broker, and sales agent needs to disclose. And then there's also broker fees. Paragraph 9 is closings. The closing of the sales would be on or before this date or within 7 days after objections made under paragraph 6D have been cured or waived, whichever date is later. And if either party fails to close the sale by the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. And there's more on at closing 1 through 4. 10, possession, buyer's possession either upon closing of funding or according to a temporary residential lease. And in bold black text, consult your insurance agent prior to change of ownership and possession because insurance coverage may be limited or terminated. In the absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. We also have smart devices B. Smart device means a device that connects to the internet to enable remote use, monitoring, and management of the following here. And there's 2 subcategories under smart devices that you can read about. Paragraph 11, special provisions. Only factual statements and business details applicable to the cell would go here. 12, settlement and other expenses. The following expenses must be paid at or prior to closing. And if there's seller, shall also pay an amount not to exceed this amount. If that's what's negotiated, then B needs to be filled in and this blank needs to be filled in. Paragraph 13, prorations and rollback taxes. A goes into more prorations and B goes into more of rollback taxes. 14, casualty loss. And if any part of the property is damaged or destroyed by fire or other casualty after the effective date of this contract, seller shall restore the property to its previous condition as soon as reasonably possible, but in any event by the closing date. And then there's default. If buyer or seller fails to comply with this contract, then either party can enforce specific performance and seek such other relief as may be provided by law, could terminate this contract and receive the earnest money as liquidated damages. And more, you can read more on default. Paragraph 16, mediation. So it is a policy of the state of Texas to encourage resolution of dispute through mediation. Then paragraph 17, attorney fees. So a buyer, seller, listing broker, or other broker or escrow agent who prevails in any legal proceeding related to this contract is entitled to recover reasonable attorney fees and all costs of such proceeding. Then we have paragraph 18, escrow. We have a escrow. The escrow agent is not a party to this contract and does not have liability for the performance or non-performance of any party to this contract. And it goes on to even more regarding escrow. B, expenses. C, demand. And then D, damages. And E, notices. Paragraph 19 is representations. Paragraph 20, that's federal tax requirement. And this, if seller is a foreign person. 21, notices. This is all notices from one party to the other must be in writing and are effective when mailed to, hand delivered at, and transmitted by fax or electronic transmission as follow. Buyer information and seller information needs to be filled in here. And then agreement of parties. This contract contains the entire agreement of the parties and cannot be changed except by their written agreement. Addenda, which are a part of this contract, are, so check all applicable boxes that actually apply. Paragraph 23, consult an attorney before signing. Track rules prohibit real estate license holders from giving legal advice. Read this contract carefully. Buyer's attorney information will go here, and seller's attorney information will go here. This is the executed date of their contract. Buyer, seller will sign here. And then broker information go here. Print names only, do not sign. And then here's the disclosure below. Option fee receipt needs to be complete. Earnest money receipt also needs to be complete. Contract receipt needs to be complete and filled out. And additional earnest money receipt if that is applicable. That is the overview of the promulgated by the Texas Real Estate Commission track new home contract, and this is for completed construction. If you have any questions or something is not clear, I invite you to speak to your mentor and broker about your questions or anything that's unclear for you. Thank you.